One of the 5 print taken by Prime Minister Narendra Modi before the country on August 15 was to end all signs of slavery. Today's 3 bills are going to fulfill this one vow of Shri Modi. These are not my words. This is how Union Home Minister and Minister of Cooperation Amit Shah introduced 3 bills in August this year to overhaul criminal law in India. However, since then, the bills have faced criticism for making the criminal laws harsher and more complicated in a way that could affect civil liberties in the country. So, in this video, I'm going to tell you what these bills say and what are some of its contentious provisions. Now, the central government, just for a bit of background, the central government introduced 3 bills in the parliament in August, like I mentioned. These were called the Bharatiya Nyay Sanhita 2023, the Bharatiya Nagrik Suraksha Sanhita 2023 and the Bharatiya Sakshya Bill 2023, and they are to replace the existing Indian Penal Code, the Code of Criminal Procedure, which is CRPC, and the Indian Evidence Act respectively. Now, the bills were then referred to a 31-member parliamentary standing committee headed by BJP MP Brijlal for review. This panel adopted its report on the bills on November 7th, with opposition MPs pointing out several errors and recommending more than 50 changes. The government then withdrew these criminal law bills and reintroduced newer versions of the Bharatiya Nyay Sanhita, which is BNS 2. The Bharatiya Nagrik Suraksha Sanhita BNSS 2 and the Bharatiya Sakshya Bill, which was BSB 2, to replace the Indian Evidence Act, and the first 2 were to replace the other 2 laws, that is IPC and CRPC. But these new versions retained several of the concerns that have been raised over the bills. Let me give you an example, and to lay down a bit of background for you here, the Constitution and the Code of Criminal Procedure prohibit detention in police custody beyond 24 hours. So, the first provision that I'm going to be telling you about is related to this custody, the police custody and judicial custody. Now, under the law currently, the magistrate is empowered to extend custody up to 15 days. This could be judicial or police custody in case investigation cannot be completed within 24 hours. The important provision here is section 167 of the CRPC. It allows the magistrate to further extend judicial custody beyond 15 days up to a maximum of 60 or 90 days depending on the extent of the punishment prescribed. So, it talks about custody, judicial and police during the investigation stage essentially. Now, judicial custody, for a bit of background, means that the accused has been detained by a judicial magistrate and is lodged in central or state prison. As against this, in police custody, the accused is detained in a police station or lockup and is in the physical custody of the police, which is why courts and the law are so careful about giving extended period of police custody, because it gives free access to the police of the accused. Now, currently in the first 15 days of detention, the custody can be changed from police to judicial and vice versa, and can also be intermittent. So, for example, 2 days of police, 2 days of judicial custody, and that can be alternated. Though a few Supreme Court benches have disagreed, the Apex Court has ruled in more than one case that police custody can only be authorized in the first 15 days of remand once the accused is produced before a magistrate, even if the accused is unavailable for interrogation by the police for some days in this 15-day period. The court has asserted that this was done to protect the accused from the methods which may be adopted by some overzealous and unscrupulous police officers. So, the new bill settles this debate by allowing detention in police custody for 15 days in whole or in parts at any time in the first 40 or 60 days out of the investigation period of 60 or 90 days respectively, therefore essentially extending the reach of police custody to later stages of the probe and making an accused more vulnerable to procedural persecution, because up until now a lot of courts and the Supreme Court had asserted, like I had mentioned, that police custody can only be taken in the first 15 days, but now the new bills extend this period in which police can have an accused person's custody. Just to let you know, the committee had also taken note of the concerns that clause 187 could be vulnerable to misuse by authority and needs clarity. As per the report, stakeholders had recommended simplifying clause 187, which they found to be too complex. Now, another provision that I want to point out to you, it is within section 167 only. So, section 167 allows the magistrate to authorize the detention of the accused person beyond the initial period of 15 days otherwise than in the custody of the police. This is an important phrase to hold on to this. Simply put, this section allows, this is the current law by the way, this section allows the magistrate to extend judicial custody beyond 15 days up to a maximum of 60 or 90 days depending on the extent of the punishment prescribed. So, after 15 days, it essentially has been interpreted to mean that the next stage will be judicial custody, the extension that is granted. Now, under section 167 subclause 2, an accused can be detained in custody for a maximum of 90 days for a crime punishable with death, life imprisonment or a sentence of over 10 years. This duration is 60 days in the case of other offences. However, clause 187 of the new bill allows detention in custody to be authorized beyond the 15-day period without the stipulation that it must be otherwise than in police custody. So, up until now, this was being understood as extending the maximum time allowed for an accused to be kept in police custody to 60 or 90 days from the earlier 15 days, and a few critics felt that this omission may be inadvertent, but others also feared that this may impinge on the rights granted to an accused under Article 21 of the Constitution. It has also been pointed out that extended police custody exposes the accused to increased likelihood of custodial violence and makes them vulnerable to forced confessions. However, Union Home Minister Amit Shah has clarified that it was a misconception that the new bill increased total custody for an accused after initial arrest from 15 to 60 days. Clarifying that the total police custody cannot exceed 15 days, he said that the provision is introduced to allow flexibility so that police can take custody in different spells over 40 or 60 days as the case may be. However, in any case, the clarification that Mr. Shah has given must be added to the new bill to make the provision clearer and to prevent its misuse, because currently that phrase that I mentioned is missing from the proposed clause. Now, another provision that I'd like to mention here is section 43. This is again from the new bill, which allows the police officer to use handcuffs while making an arrest or producing such a person in court, keeping in view the nature and gravity of the offence. Handcuffs can be used on a person who is a habitual or repeat offender, or who escaped from custody, or who has committed an offence of organised crime, terrorist act, drug-related crime, illegal possession of arms and ammunition, murder, rape, acid attack, counterfeiting of coins and currency notes, human trafficking, sexual violence against children, or offence against state. So, it has a list of offences under which if a person is accused, he can be handcuffed. This, however, is despite the fact that the Supreme Court has held in the past that handcuffing is prima facie inhuman, unreasonable, arbitrary, and violates Article 21 of the Constitution. The Supreme Court has ruled that in the extreme cases that a prisoner needs to be handcuffed, the escorting authority must record reasons for doing so, and the police needs to obtain special orders from the magistrate for handcuffing. However, the provision does not incorporate any of these safeguards that the Supreme Court has laid down so far. Another contentious provision in the new bill is section 152, which talks about acts endangering sovereignty, unity and integrity of India. This is proposed section 152 of the bill that seeks to replace IPC. Now, in May last year, the Supreme Court put on hold all pending trials, appeals and proceedings with respect to charges under the sedition law till the centre completed its exercise in re-examining its provisions. This was done on a plea challenging the sedition law, which has been misused and has remained contentious over the years. While the new bill BNS 2 does not use the word sedition, it adds section 152. So, currently section 124, which talks about sedition law, makes it a crime for anybody to bring or attempt to bring in hatred or contempt or excite disaffection towards the government. It can be by spoken or written words or signs or visible representation. The provision provides for a life imprisonment or a 3-year jail term or fine. The new proposed amendment provides for punishment of 7-year jail term or life imprisonment for anybody who excites or attempts to excite secession or armed rebellion or subversive activities, or encourages feelings of separatist activities, or endangers sovereignty or unity and integrity of India. This can be done through spoken or written words, or by signs, or by visible representation, or by electronic communication, or even by use of financial means. So, essentially it reintroduces sedition in a way without using the word, while making the provision more vague, open-ended, contentious and open to misuse. Let's look at another provision in the new bill. So, the bill provides for the definition of a terrorist act. Again, this is BNS 2. which so far was defined by section 15 of the UAPA. Now, the previous bill was criticized, the first bill was criticized for introducing new elements to the offence. Now, the new bill brings the definition close to the one already provided under UAPA. However, there's a glitch. Now, an explanation to the section says that before registering a criminal case or an FIR under this clause, there has to be an approval by a senior police officer to decide whether the FIR should be registered under UAPA or under the new law. So, it can be done either. However, it does not provide any guidance on the basis on which the police officer should make this decision. This may also lead to different probes and trial procedures for similar offences. For example, cases under UAPA are tried under the National Investigation Agency Act 2008, which establishes special courts to try such cases. However, under the new bill, the same offence will be tried in the Sessions Court. So, that could lead to the same sort of offences or allegations being tried under different procedures in different courts. So, this could create a lot of confusion again. Now, the Parliamentary Standing Committee had also made several suggestions that have not made it to the new bill. One prominent one is that we all know that section 377 of the Indian Penal Code was struck down by the Supreme Court to the extent that it criminalized same-sex relations between consenting adults. However, the committee noted that non-consensual sexual acts of unnatural order are still prosecuted under this section. So, it asserted that the remaining part of section 377 of IPC, which is still valid, should be retained in the new bill appropriately. Despite this, the new bill does not contain any provision for non-consensual sexual offence against male, female, transgender or for bestiality. So, these are some of the provisions that have or could turn out to be contentious once these bills become laws. Of course, we are going to keep an eye out on these bills being passed and how these provisions are finally being interpreted. So, keep an eye out on our YouTube channel as well as our website for videos and articles on these laws and all the other bills that are being taken up and being passed by the Parliament. I hope you enjoyed this video. Thank you so much for watching.